Well done. Right, good morning, ladies and gentlemen. Welcome to this meeting of the Public Petitions Committee. First thing I have to do is remind everyone, please switch off the mobile phones. I have apologies from David Stewart, the convener, and Adam Ingram, and Malcolm Chisholm is standing in for David Stewart, and Jimmy D is attending as Adam Ingram's substitute. The first thing is agenda item 1. Ask the committee if they agree to take that item in private. And 6 and 7.
Agreed.
Okay. Right. Agenda item 2 is a petition on the effective thyroid adrenal testing, diagnosis and treatment. I particularly welcome the Cabinet Secretary to give evidence, and Ms Dunk and Ms Mayer. I would ask if Cabinet Secretary wishes to say anything quickly, and then we'll get into hopefully very brief questions, and I'm going to try and close this down in half an hour. So.
Yeah, thank you, Convener. Very briefly, just to say thank you for inviting me to give evidence on the concerns over thyroid and adrenal disorder patients' access to medication. Very briefly, the committee will be aware there has been a recent interruption to the supply of one of the medicines used to treat thyroid conditions, liotherine. I understand that supply has now returned to normal and that new stock is now available. However, I also understand that interruptions of this nature to the supply chain can be very distressing for the patient, particularly when there is no alternative licence source for the medicine available in the UK. Unfortunately, medicine shortage issues of this nature do arise from time to time, and the Department of Health in England has responsibility for UK medicine shortages and acts on behalf of all UK health departments in these matters. Scottish Government officials do keep in regular contact with the Department of Health to consider any UK-wide implications, and we continue to do so. The Scottish Government is also in regular dialogue with the pharmaceutical industry, pharmacy wholesalers and pharmacists in order to minimise the impact of any supply chain problems on both patients and the NHS, and I'm happy to answer whatever questions the committee has, Convener.
Thank you, Cabinet Secretary. I wonder if I may start asking a question. Is there any evidence that drug companies are restricting supply on the basis that might help force prices up?
No, certainly not in this case. I mean, I think one of the issues here is the number of patients in Scotland who are prescribed this particular drug is of the order of 420 to 450 patients, and across the UK is probably around the 5,000 mark. And obviously, given the relatively small size of the market and also the very expensive raw material and the expensive and complicated manufacturing process for this particular drug, the source of the problem here very clearly in terms of the recent shortage was the shortage of the supply of raw material for the drug. There was no sign at all, and no evidence that there was any profiteering or deliberate manipulation of the market going on by any of the people involved in the supply chain.
And may I ask, how soon were you made aware of a problem of this nature?
Well, it tends to obviously percolate through the system reasonably quickly. We're in regular contact with the Department of Health, and we've discussed with them different ways in which we can address this problem. I mean, obviously the priority is to try to get the supply reconnected as quickly as possible, and all action was taken to do that. Secondly, we look at alternative medicines that could be supplied. And in this particular case, for some patients anyway, the only real alternative medicine were medicines which are licensed for marketing purposes in continental Europe, but which were not actually licensed by the MHRA in the UK. However, the MHRA, I believe, issued guidance allowing the use of these medicines on an interim basis until the supply of the original medicine was reconnected.
Okay, thank you. Malcolm Chisholm.
And that was actually very useful. I've actually written to you about another medicine that's not available at the moment, so your reply on this one will obviously be relevant to your reply on that one. So that's clear. I suppose the other issue that the petitioner is raising is although I'm obviously a bit late into this, but I understand it's to do with a single licensed drug. So I suppose there's an interesting question about when there is a single licensed drug. Is that kind of like a conscious decision of the MHRA, or is that because manufacturers have not applied for a license for an alternative drug, or because they've applied and been turned down? I mean, I suppose there's not a general answer to that, but I don't know if you could answer with reference to these kind of drugs for thyroid deficiency.
Basically, in terms of these drugs, to be quite blunt about it, because of the small number of patients who benefit from these drugs, the number of suppliers is very, very small indeed. Because quite frankly, it's not a big part of the market, and obviously the pharmaceutical companies obviously concentrate their efforts on where they think the greatest supply will be. So this is, in terms of the market for drugs generally, this is a very, very small cohort of patients who require this drug and who would benefit from this drug. And therefore, the number of suppliers, in fact, I think there's really only one supplier, I think I'm right in saying, in the whole of Europe for this particular drug.
There's more in Europe, just one.
So more in Europe, sorry, one in the UK.
I mean, we have a note from the petitioner saying that, I think it's the petitioner anyway, saying that she uses a different one that she finds more effective for her. I don't know, I imagine she pays for it herself, and right. It reminds me of a constituent of mine who actually came with reference to Armour Thyroid, which has also figured in these debates. And I mean, that raises a whole lot of other interesting issues, because I suppose her point was that's the only drug that works for her, but it's not licensed and she has to pay for it. So, I mean, I suppose that the issue that then arises is, what's the position for a GP who prescribes an unlicensed drugs? I think in her case, I don't think the GP was saying it wasn't effective for her, but obviously there's a lot of risk. I understand there's a lot of risk attached if a GP does that. So I could see it from her point of view that she knows that one drug works for her that she has to pay for. So I imagine that may happen in other circumstances for other patients.
There's very clear MHRA guidance which is issued to clinicians in terms of what is licensed and what's not licensed. And obviously, if you prescribe an unlicensed drug, that may have implications in terms of liabilities if anything goes wrong. And the MHRA guidance is quite detailed in all of these areas. In terms of the wider issue though, Malcolm, I think in terms of the petitioners, my understanding is there are related issues in terms of how effectively some people are being treated overall for this particular condition and related conditions. My understanding is the committee is planning a round table on some of these wider issues after the recess, and Michael Matheson and our officials will be, will certainly offer to participate in that round table because we want to get to the bottom of the concerns that the petitioners have, not just in relation to the supply of drugs, but also in the wider issues where they believe that the treatment sometimes being prescribed for them isn't what it should be, particularly from GPs. So we want to try and get the evidence on that to find out what the problem is or appears to be, to see if we can then address the problem.
Jimmy D, you wanted to ask?
Thank you, Convener. Good morning, Cabinet Secretary. Your evidence today has been very helpful in painting the picture of where we are, but just to get a fuller understanding of the situation, I just wondered, you said during the period of the disruption to the supply chain, there was a medicine that is not licensed in the UK that was made available on an interim basis, if I heard you correctly. Do you have any understanding from discussions with the MHRA as to why there is only one licensed medicine in the UK, why only one manufacturer has applied for a marketing authorisation?
I'll ask Alpana to give you more detail on that. They'll place it for you.
Okay, it's really just the fact that the Cabinet Secretary alluded to earlier, the fact that there aren't as many patients affected by it, so it's really up to a company or a pharmaceutical company to decide to manufacture it, and at the moment there is only one. It's a very complicated process to manufacture this particular product in terms of its production, so it would not be in many companies' interest to go into that market because it's a very niche market, and that's really why.
But the medicine that is not licensed in the UK that was made available on an interim basis, is that licensed in other countries?
It is. It's the liothyronine that's manufactured for supply to their respective countries. So there's one in Germany, for example, who have the licence for production in Germany, but it's not licensed for
So for commercial reasons, that company has decided not to
apply for a
apply
licence
in the UK.
Yeah.
Okay, thank you.
Amick Taggart.
Thanks, Convener. Good morning, Cabinet Secretary. Really just to find out what part, and trying to rectify this situation that you had, Cabinet Secretary, what part did you play in the work undertaken by the MHRA and the Department of Health to try and rectify the situation?
Well, it's mainly done at official level because obviously these are things that don't necessarily always involve directly ministers, either north of the border or south of the border. My job is to make sure that necessary action has been taken. And certainly when the issue was alerted to me, my job was to make sure that we were doing everything we possibly could in cooperation with our colleagues and friends down south to reconnect that supply as quickly as possible, and meantime to make sure, along with the MHRA, that our clinicians in Scotland were aware of the interim arrangements, and that was the role of the Scottish Government at that period.
Thanks, Cabinet
Okay.
Secretary.
John Wilson.
Thank you, Convener. Good morning, Cabinet Secretary. The bulk of the question that I was going to ask has been already been asked, covered by Malcolm Chisholm, but there is an issue in terms of security of supply, Cabinet Secretary, and we welcome the decision that was made to actually bring in unlicensed medicine at a time where there was a shortage. What can be done to increase the security of supply, and has there been any discussions either at Scottish level or UK level about trying to get some of the drugs that are licensed on the continent licensed in the UK? Because what we also heard by some witnesses and some evidence we've received is that some people feel that the drugs that are available in the continent are actually better than some of the drugs that are available in the UK and Scotland.
I think there's two questions really there. First of all, in terms of contingency arrangements, we are working with our colleagues both south of the border and indeed with the other devolved administrations to try and get more robust contingency arrangements in place, so that if there is any future disruption to supply, then it can be dealt with in different ways and more speedily than perhaps has been always the case in the past. I don't want to go into too much detail about that because it involves commercial negotiations with the companies involved, and you would understand I wouldn't want to disclose too much to their advantage and rather keep certain bargaining chips up our sleeve. But in terms of the general point, we are absolutely, along with our colleagues in London, very conscious of the need to have more robust contingency arrangements in place for the eventuality of where there is any shortage, not just in relation to this drug, but more generally. But specifically, it's this area that has tended to be the worst, I think, in terms of shortages in recent times anyway. So the general principle of contingency arrangements is absolutely agreed, and we're working on that. In terms of the second point of encouraging these companies that have not got these products which are available on the continent to be encourage them to apply for a licence in the UK. Again, at the moment, that has to be done through London. It's a reserved matter. But it would seem to me the UK, I would have thought, compared to the likes of Germany, is not an insubstantial market. I mean, the German population is just over 80 million. The UK population now is over 60 million. So I would have thought that these companies would be and should be, from a commercial point of view, looking at the UK market as an area of expansion. But we can't force these companies to apply for a licence in the UK. Obviously, if they do so and make alternative medicines available, then that's all to the good as far as I can see. But we can't force them to do it.
Cabinet Secretary, the petitioner has raised with the committee the issue about the cost of some of the medicines that are being made available. And they have done a price comparison, and I'm not sure, I haven't analysed it in terms of but what they're effectively saying is that the price comparison between the drugs that are available on the continent are a lot cheaper than the drugs, the prices for the drugs in the UK. I know that you won't be able to comment too much on this, Cabinet Secretary, but could I ask you to inquire with your department as to the pricing regimes that are being applied, and it may involve, as you said, discussing with UK officials but just to check out the pricing regimes, because if we have a licensed drug and based on some of the charging prices charged that we've got in front of us, then clearly there is a major issue where some of the drugs are being charged at 10 times more than what they're being charged to health authorities in the continent.
Can I say pricing is also a reserved matter, but we are very keen where we can to reduce the price of drugs. You know, overall, the National Health Service will spend this year just short of £1.4 billion out of our total £12 billion budget on prescription drugs. That's a lot of money, and if we can identify savings, which we are doing in a number of ways, but if we can identify further savings, we would be delighted to do so. And again, it's an issue that we're in discussion with our colleagues in London about.
Cabinet Secretary.
Angus MacDonald.
Yes, thank you. Good morning, Cabinet Secretary. I'm certainly pleased to hear that the supply of liothyronin has returned to normal. Now, I think part of the point I was going to raise has been covered. However, I'd be keen to hear what the Scottish Government does to routinely monitor potential supply problems of any medicine, and are there any other medicines that are experiencing supply problems at the moment?
Well, I think I'm right in saying at the moment we don't have any immediate shortages. Is that right?
There are some products that are affected, but usually what happens is that again, the Department of Health monitors any shortages that may be potential to cause an issue and try to avert those by suggesting alternative products, or advising pharmacists how they could access alternative products, and also advice to clinicians on how they could deal with those. So from time to time there are some shortages that arise, but usually there's a mechanism in place that picks up shortages problems before they actually affect patients and tries to put in contingency arrangements to try and avert those, or provide guidance where those can't be avoided at all.
But you clearly would have an issue if there was a similar situation to this where an alternative wasn't available.
It could do, but usually in most instances there are alternatives. The ones that have happened recently, there have been alternatives that have been available to prescribers to issue in place of the shortage product. It tends to be formulation issues, for example. So one formulation may be out of stock, but clinicians could use an alternative formulation to supply that instead.
Okay, right, thanks.
Can I just ask on that, would they recommend unlicensed product?
Well, the MHRA have issued guidance to allow the use of products that are licensed elsewhere but not licensed in the UK on an interim basis, but it's on an interim basis. Is that right?
Jackson Carlo.
Morning, Cabinet Secretary.
Good morning.
Can I take you back to something you said earlier in relation to the general point about the diagnosis? I'm just concerned when we talk about niche market, because obviously what's been established is that 3.7% of patients are being diagnosed. That's 103,000 people, which kind of elevates it in many people's minds above a niche market. And part of the concern is the ability of GPs to properly diagnose it. Now, you said you were going to try and investigate that deeper part of the petition, and I just wonder if you could say how that investigation you intend that investigation to proceed.
Well, first of all, in terms of the niche market, I was referring very specifically to this particular drug where we reckon there's no more than about 450 patients in Scotland receiving this drug. Now, of course, there's an argument about whether more patients should be getting prescribed it, obviously. But even in terms of the general scheme of things, it still is a very, very small part of the overall pharmaceutical dispensary market in Scotland and indeed in the UK. In terms of the wider issues, we've already been looking at what the petitioners have been saying in submitting their petition, and I'm going to ask Rachel to say a word or two about some of the work we've already done, but we're also going to, as I said earlier, participate hopefully in the round table discussion with the committee, because we want to get to the bottom of why some people believe, and the petitioners clearly believe, that the service they're getting in primary care isn't always what they should expect, and obviously the petitioners have made it clear it falls short of what they would anticipate in terms of the service that they've been provided with. Now, we're not finding evidence of that, but we want to find out from the petitioners and others where their evidence is, we can then investigate that, and our clinical priorities team, which Rachel is a member of, is looking at this issue and trying to gather the evidence to see if there is an issue that we need to address by way of future guidance, or in whatever way we need to address it. But I'm going to ask Rachel to give you some more detail on the work we've already done.
We're undertaking 3 main streams of work at the moment. One is consulting with the British Thyroid Association, so we've asked for their views on the petition, the points made, etc. We have asked Health Improvement Scotland through their Scottish Health Technologies Group to undertake an evidence note on all the available published clinical evidence in relation to this matter. I understand from previous meetings that the petitioners don't feel that research to date has been particularly supportive of their position, or that not enough clinical trials have been undertaken to prove their position. But again, by a look at all the published clinical evidence, it may be that the conclusion is that further research needs to be done, potentially in liaison with the Chief Scientist's Office, etc. And we're also liaising with the Diagnostic Steering Group at the Scottish Government to reach the diagnostic MCNs in order to deal with some of the issues around the testing, the idea that the TSH test is not sufficient on its own and that further testing is required. So we're looking at those issues, but obviously we've tried to sort of look at the bits that perhaps haven't been raised around the committee table and gathered the evidence from them, but we're also very interested in what the petitioners have to say, and want to take that all into account in the round when we report back to the committee.
Thank you.
The thing I want to stress, Convener, is we are taking this petition very seriously and what the petitioners are saying, because we do want to get to the bottom of the problem and try and make sure that we go forward in a way that's acceptable to everybody and that people are getting the health service they would wish for.
Thank you, Wilson.
Thank you, Convener. Just a brief supplementary, and I was interested in Ms Mayor's comments about clinicians and primary services being made aware if there's going to be drug shortages. One of the issues that was raised by the petitioners is that the individual patients weren't aware, and basically it wasn't until they went to get the prescription, to fill the prescription for the particular drug, that's when they found out from the pharmacist that the drug was not in manufacture at that present moment and there was no supplies available. And the petitioner described a trawl round pharmacies around Scotland to try and get the prescription filled. Can we expect more consultation with patients regarding the lack of or shortages of particular drugs that they are used to taking? Because one of the things that has been raised by petitioners is that they are confident in a particular drug. If that drug is not available, then they feel less confident with alternatives.
I think there is no doubt we need to look at the communications in these cases. We ourselves have no direct contact with patients through the GPs and the pharmacies, but we will take that as a specific issue to look at to see how we can make sure that the information, and not just the information about the shortage, but what people should do in the event of a shortage, gets to the patients. We try our best to make sure that that information is being passed on. Clearly that hasn't been robust enough in some cases, and we'll look at that and see how we can improve that process, because I think we clearly want to notify patients as early as possible that there is or may be a problem, but more importantly, what they should do in the event of a problem.
Thank you, Cabinet Secretary.
Any other questions?
Can I just have a tiny one? Cabinet Secretary, I do have a constituency inquiry that I'm not going to go into, but the pharmacy gave only half the prescription, and given that and has said that there is a shortage, so they've only got half the prescription. Can you tell me what I would advise them then to go on?
Well, it may be that they're expecting the other half fairly soon. I don't know the circumstances, obviously, but if you want to write to me with the details, and I'll certainly have it investigated.
Thank you.
Just one last question, if I may, Cabinet Secretary. John Wilson alluded to the pricing mechanism, and we have an example where the price of the product from one source is double the price from another. I just wonder, what influence do you think you have and the government has in relation to MHRA licensing and contracts and therefore pricing?
I think at the moment, the influence is whatever influence we have collectively, I think, as devolved administrations on the Department of Health in London. But very clearly, one of the reasons I'm in favour of a yes vote is that we would have substantially more influence in that situation.
Thank you. Any other questions for the Cabinet Secretary? Right. Can I just say the committee that we have a recommendation in front of us, and as the Cabinet Secretary alluded to, the possibility of a participation in a round-table discussion at a meeting shortly after the summer recess. And you have in your papers a list of the organisations that might be invited. I just ask the committee, is there any other body that might be, that you feel might be invited to this round-table? Or is there any other action that you wish us to take? John.
Convener, given the Cabinet Secretary volunteered the Minister for Health, Public Health to attend the round-table, could I suggest we invite the Minister for Public Health along to that round-table discussion?
Yeah.
Officials.
With relevant officials.
Yeah. Anything else? Are we agreed? Round-table discussion shortly after research. After some recess, to include the Minister for Health with officials. That agreed? Okay, thank you. Can I thank Cabinet Secretary and Ms. Dunk, Ms. Mayor, and for attending today and being very clear in the answers. And if we can just break for a few minutes to allow the witnesses to leave. Thank you. Item of business is taking evidence as part of our very significant inquiry into tackling child sexual exploitation in Scotland. I welcome the panel, Lord Advocate, the Right Honourable Frank Mulholland, Alison Derolo, Head of National Sexual Crimes Unit, Crown Office and Procurator Fiscal Service, and Assistant Chief Constable Malcolm Graham of Police Scotland. We have questions that we wish to address to individual members, but of course that doesn't preclude that question being extended to other members. We have a lot of questions, and it may well be, in fact, not may well be, it's almost certain that we will not cover all of these in our verbal exchanges today. So our intention would be to write with some of these questions and receive the answers at the appropriate time. On the basis that we have a substantial number of questions, can I ask for brevity both in terms of questions and answers? And I would ask the panel if they have anything to say briefly at the beginning of their evidence.
Thank you, Chair. I have some brief opening remarks, and I think Malcolm Graham to my left has also some brief opening remarks, so I'll just get on with it. Firstly, thank you for inviting me to give evidence to the committee. I have with me Alison Derolo, who is Senior Crown Counsel. She leads National Sexual Crimes Unit, which was set up in June 2010. we hope to answer your questions and quite happy if there's anything that's not been covered to then deal with it later in writing. Sexual abuse and exploitation is a key priority for the Crown Office and Procurator Fiscal Service. Having served as Crown Counsel for a lengthy period of time and having prosecuted many of these cases over the years, many of them involving children, I came to the realisation that specialist prosecutors and investigators were required in this challenging area. And that is why National Sexual Crimes Unit was set up in 2010 with the aim of bringing knowledge, expertise and experience to this challenging area of criminality. The National Sexual Crimes Unit stands at the head of a matrix of sexual offence teams in 3 federations, that's East, West and North. All members of these teams are trained in dealing with sexual offences involving children and understand the dynamics at play here, such as delayed reporting, grooming, empathy and loyalty towards the perpetrator even after the exploitation and abuse has been discovered, peer pressure, lack of understanding that they are victims. They are skilled at interviewing and leading evidence from vulnerable and damaged children whose vulnerability has been exploited, often leading to the most horrific of circumstances. Alison de Rollo is also lead for Scotland in human trafficking, bringing a consistency of approach and a real understanding of the issues in this area. Before I conclude my opening remarks, I want to raise a couple of matters for your consideration. We recognise that victims in this area are often targeted for their vulnerability. It's not uncommon to find that victims are very damaged, may have drug and alcohol issues and live very chaotic lifestyles. It's a huge challenge. However, the focus for prosecutors must be on the credibility of the allegation being made rather than failing to bring cases because of perceived weaknesses in the victim. And that's why the approach of the National Sexual Crimes Unit is to build strong cases by linking evidence working at an early stage with police and prosecutors, procurators fiscal. Secondly, sexual grooming and exploitation of children happens in the shadows, out with the gaze of responsible adults and law enforcement. It's often very difficult to obtain sufficient evidence, corroboration of the victim's evidence. By the time the abuse is discovered or reported, often forensic and medical opportunities are lost, and a skilled abuser will not say anything incriminating on the advice of his lawyer. In these circumstances, prosecutors will, with a heavy heart, have no option but to instruct no proceedings despite the quality of the evidence being above the prosecution test threshold of reasonable prospect of conviction. For example, in cases reported to Procurators Fiscal between 2010 and 2013 under the Sexual Offences Scotland Act 2009, where the victim is a child, 569 charges were not proceeded with. 321 of those charges were as a result of insufficient evidence. So that concludes my opening remarks, and I think Malcolm Graham wishes to say a few opening remarks, and at the end of his opening remarks, I'd be delighted to try and answer your questions.
Thank you. Mr. Graham.
Thank you. I'd like to echo Mr Mulholland and thank the committee for the opportunity of providing evidence here today in what is a key priority for Police Scotland. As anyone will know who has listened to the media and read reports of the very simple objective of Police Scotland, it's about keeping people safe. And children, and particularly the vulnerable, are absolutely at the top of the list in terms of keeping people safe. The prevention and investigation of child abuse has been a high priority for police and partners in Scotland for some time. Child sexual exploitation is a recognised strand of child abuse. In some instances, new technologies and behaviours have created significant challenges for policymakers and practitioners, not just in policing. And child sexual exploitation is a form of child abuse which is currently receiving high levels of public and media scrutiny, largely due to widespread interest and perceived shortcomings in some recent high-profile investigations in England and Wales. Police Scotland continues to work very closely with local partners through participation in child protection committees and adult protection committees to develop multi-agency guidance and protocols in a variety of business areas which overlap with child sexual exploitation. Each of the local child protection committees in Scotland is at varying stages of progress in relation to developing specific child sexual exploitation protocols, and this is something that Police Scotland is driving through the country. Difficulties can and have been encountered in developing a shared understanding of the issue across statutory partners and third sector providers at a national level, and it's considered that there is need for national coordination and oversight to drive local CPC activity and other activity to ensure that children are kept safe. The creation of Police Scotland provides a fantastic opportunity to enhance national policy, coordination and operational responses to child sexual exploitation. And there are several things which I would like to highlight specifically that have happened since the 1st of April, which have provided an enhanced response in this area. The formation of a national rape task force in structure, locally delivered in 14 local police divisions, with a national coordination centre, a national rape investigation team, and a national rape review team working with the National Sexual Crimes Unit in the Crown Office Procurator Fiscal Service. This ensures, quite rightly, a local response to the large number, an increasing number of sexual crime reports that are received, but most importantly, has allowed us to understand better the nature of the problem across Scotland and to ensure that the quality of investigations and the quality of interactions with victims and other witnesses is consistently driven up through a review process and rigorous quality assurance measures. Sitting alongside the National Rape Task Force, we now have a National Human Trafficking Unit. They're part, in effect, of the same department, but have dedicated staff. There's a clear focus on trying to identify and safeguard any children or young people who would be victims of trafficking, and already there has been some results in terms of the identification of victims of trafficking who otherwise we believe would not have been identified. And finally, and most recently, as we continue to evolve and develop Police Scotland, we're in the process of implementing a national child abuse investigation unit. This will build on the structure of the Rape Task Force and the Human Trafficking Unit, in that it will be a relatively small but specialist national unit who will provide coordination, investigation into the most high-profile, complex investigations which cross boundaries, and which will be responsible for ensuring quality and driving up standards in each of the 14 divisional public protection units who are responsible for working with local partners on a day-to-day basis. So I'll go back to where I started. Child abuse is a high priority for Police Scotland, and I welcome the opportunity of answering the questions about how we continue to improve our response to the specific issues relating to child sexual exploitation, and I'm happy to answer questions. Thank you.
Thank you. I wonder if I then may start with questions. First of all, may I ask Decision Chief Constable Graham, you've highlighted some of the action that's been taken, and I'm sure is very welcome. How are you relating that work to the work that we're currently doing, or indeed the government is doing? It seems that the police are doing a lot of what looks as if it's independent work, but how is that being collated with work that hopefully will come from our inquiry, and also some work that the government is doing?
Thank you. Well, hopefully I was at pains to express that policing in partnership is the only way that we're going to safeguard children and other vulnerable people, and particularly that's true of child sexual exploitation. We've seen an increase in the reporting of sexual crime in recent years, and I believe strongly that that is down in large part to an increased confidence of victims to come forward. What we understand about child sexual exploitation is that victims are perhaps least likely to come forward, perhaps as has already been said, because they're less likely to perceive themselves as being victims. Therefore, working in partnership, both at local and national level, is the only way that we're going to improve our responses. In relation to the specific point about working with the Scottish Government, the police are key stakeholders, have been for some time in relation to the various strands of developing what I believe to be an extremely strong child protection network and system of protecting children across Scotland. Previously, ACPOS and the 8 legacy forces were engaged with Scottish Government in all aspects of that. And more recently, since the creation of Police Scotland, I sit on the Ministerial Task Force Working Group for Child Sexual Exploitation, which is led by Children in Scotland but supported by the Scottish Government. And by taking part in this process today, we're very happy to share our views on where we believe policy needs to go and work with others to make sure that we're making best of the opportunities we have to identify victims and safeguard.
Okay, I think that's very important and welcome. Just because my next question was really to Ms. de Roo in terms of looking at your evidence and looking at the figures behind it. If I look at in your letter, you mentioned Section 10 of the 2005 Act, causing a person under 18 to become a provider of sexual services or to be involved in pornography. It's not even mentioned in the facts in the appendix. Is that because there's been no prosecution? Why has there been no prosecution? I mean, surely there must have been some situations where one might have been prosecuted under that particular provision.
There may have been reports, but I think it's important to recognise in this whole field, and I think what we were trying to convey in our submission, and hopefully we'll explain further today, is that the activity involved in child sexual exploitation in Scotland does not fit into neat categories. We require, and we do have an extensive toolkit in the sense of statutory offences, some common law offences as well, which we will apply to the facts and circumstances of each case reported to us. So the need and the professional objective is to prosecute on the evidence that we are given in the best way possible, the most appropriate way possible, in order to secure convictions. Now, what we have then, for example, a section that we have used more often under the 2005 Act, the grooming section, which I think raised expectations, and I think people may look to that as a signpost as to how well we're doing. But the committee must be aware that that section covers a relatively limited snapshot of the sexual activity that we're talking about. It reflects activity which has gone beyond preparation but not quite achieved perpetration. So we have taken proceedings for those who have contacted, made arrangements to travel with the intention of having sexual activity. But where those people have gone on to have sex with these vulnerable children, then a whole different panoply of crimes comes into play. And I must stress that when we get reports from the police, our job as specialist prosecutors in NSCU is to look at the whole range of statutory options available to us, and we will always prosecute the most appropriate offence.
If I could just come in on that, just to set out the technicalities, just building on what Alison said. If you receive a report from the police which alleges grooming and then there's a continuum into sexual abuse, sexual intercourse, the way the charge will be libelled is it always be libelled as the most serious charge, so that would be libelled as rape, and the grooming aspect of it would be part of the evidence to support the charge of rape. If the accused is convicted, then Disclosure Scotland or the court will record it as a conviction for rape, not a conviction for Section 1 of the 2005 Act. So that's something that you should always bear in mind, that the prosecutors will always libel the highest or the most serious charge that they have and use less serious charges as part of the narrative to support and prove the most serious charge.
Okay, I understand, but just looking at these facts and seeing the number of prosecutions, I mean, there's Section 9 as well. I mean, clearly we have to understand better the technicalities and hopefully we'll have that from today. John Wilson.
Thank you, Convener. Just before I go on to my main question, Convener, just seek clarification from the Lord Advocate. Lord Advocate, you indicating that Section 1 of the 2005 Act has to be strengthened in some way if the prosecutions are taking place under other offences rather than the legislation that was intended to catch perpetrators?
Well, the legislation is catching perpetrators. For example, just to build on what I said earlier, If the conduct which is reported to the police is grooming, then we'll libel Section 1 of the 2005 Act. If it's grooming leading to sexual intercourse against consent or underage, we'll libel the most appropriate charge for that. So it's not a case that we're trying to sort of or bypass Section 1. It's just that the way charges are libelled in relation to the criminal law, as it always has been in Scotland. So, for example, just to another common law example, if you have an assault or physical assault as part of a rape, then what you'll do is that on conviction the charge will be recorded as rape. And that's just the way in which the courts record these crimes. So it's not a case of trying to avoid prosecuting under Section 1.
Lord Advocate, the Crown Office and Procurator Fiscal Service says that it will prosecute all such CSE cases where there is sufficient, reliable and credible evidence. Could you provide us with a definition of what you mean by reliable and credible? Because in your earlier opening statement, you indicated since 2010, and I may have picked this up wrong, there's 569 cases being reported. 321 of those cases were subsequently dropped due to insufficient evidence. That works out, equates to approximately 60% of the cases taken forward have been dropped. Could you give some indication of what you mean by reliable and credible evidence, and how do we increase these figures to make sure the evidence that is being provided by vulnerable young people is seen to be more reliable and credible? Firstly, in relation to that statistic, the 569 charges, that's the total number of charges which you couldn't take up. In other words, were marked for no proceedings. That doesn't include the charges that were taken up, if you see what I mean. That's only looking at the no proceeding rate. So the 60% is not, or so, 60% is not the percentage of the overall number of charges reported to Procurators Fiscal involving allegations of child sexual abuse. It's that is a percentage of the number of cases which you cannot take up for whatever reason. To answer your question directly, what happens when you receive a report from the police involving allegations of child sexual abuse? Direction will be given to the Procurator Fiscal as to how they should go about preparing that case or investigating that case for a decision by Crown Counsel. That will involve an analysis and assessment of statements, supporting evidence, any forensic evidence, any medical evidence. It will also involve a process whereby the victim is seen by the local Procurator Fiscal, process referred to as precognition, where the child victim has the opportunity of going over their statement, asking questions, and assessment is made of vulnerability as to whether or not evidence should be given by special measures to aid the evidence giving of the child. And at the end of all that process, the case is then put together, a narrative is prepared, and most importantly, an analysis of the case is then prepared. That's sent to Crown Counsel to consider, goes to NSCU, who have long and lengthy experience in these type of cases. And what they then do is they apply a number of tests. Firstly, sufficiency. There has to be sufficient evidence in law, regardless of whether or not it's the most credible victim in Scotland. If there's insufficient evidence and you can't do anything about it, you can't take the case up, you can't indict it. It may be that the Fiscal's instructed to do further inquiries to try and achieve a sufficiency, but at the end of the day, if there's insufficient evidence, that's the end of the process. At that stage, we'll take a decision on whether to intimate the decision. So in other words, do you intimate it to the accused or his legal advisors? That has a consequence. If you intimate it to the accused or his legal advisors, that's you barred. You cannot re-raise that case if further evidence comes to light. It is our practice, always, to sensitively advise the victim of the decision and the reasons for it. And again, there's a skill set required for that. The next stage, if there's sufficient evidence in law, is to assess the credibility and reliability of the allegation. So you look at the case as a whole, you apply their judgment,
on experience as to whether or not that case is likely to prove, and the prosecutorial test which I referred to is reasonable prospect of conviction. That test essentially involves an assessment of whether on balance, there is more likely than not than the case proceeding. If the answer to that is yes, we'll then indict that case or prosecute it summarily, but the majority of these cases are indicted. So that's the process that's involved.
But Lord Advocate, in terms of the figures you've given, and thank you for the correction in terms of 569 cases that did not proceed, out of a total number of how many cases presented?
I don't have that figure, but I can. I'll write and give you the total number.
It would be useful just to do a comparison, Lord Advocate, in terms of the numbers. But further to the evidence you've given, the issue, we're comparing what's happening south of the border in England, and we know that Keir Starmer, Director of Public Prosecutions in England, has given some guidance on how they intend to take forward cases, particularly in light of some of the Savile inquiry and some of the high-profile cases in England. Is the Lord Advocate and his officials minded to review or bring forward any recommendations to review how we proceed in Scotland with cases of child sexual exploitation?
Well, we continually review our processes. And part of the procedures that I encourage is that case reviews are conducted after successful or unsuccessful prosecutions. It's how you learn lessons and how you adjust your approach to these matters. I'm aware of the CPS issuing guidance fairly recently on their approach centring on the allegation, the credibility of the allegation, as opposed to the credibility or reliability of the victim. I think in Scotland that we look at, and have for some time now looked at, the credibility of the allegation. We are well aware of the difficulties. If you're going to groom a child for sexual exploitation, it's a well-known dynamic that you pick vulnerability. So in many of these cases, the complainer has difficulties, drug abuse, alcohol abuse, running away from home, in trouble with the police, a whole raft of difficulties. So you can't judge a case just on the victim's lifestyle. What you've got to do is you've got to judge the allegation itself when you look at credibility and reliability. But I'm not precious about how we do things in Scotland, and I'm not in any way suggesting that we've got the answer to everything. What we'll do is we'll continually review how we do things as we go along. NSCU, 3 years of experience. So I think it's a good thing to review and ask yourself searching questions. So we'll continue to do that.
Thank you.
Angus?
Yes, thank you, Convener. Good morning, panel. The submission from Police Scotland mentions an interim national vulnerable persons database, or VPD, has been developed to record all child and adult concerns, including a category for CSE. Now, we're aware that this will help standardise police recording of CSE with, I believe, the national training package due to commence in a few weeks' time. Now, clearly this is extremely welcome. However, how will it be possible to capture the range of young people at risk when so little is known about the scale of CSE? And would a database of suspected adult offenders not be equally valuable?
Well, I'm grateful for the recognition of the developments in information technology, which have been a challenge. And I think some of the questions from the committee, which were directly specifically at the police, quite rightly focused on difficulties in coordination when we had 8 police forces under a structure of ACPOS and the SPSA. And now that we've moved into Police Scotland, we have seen some fairly rapid progress, not only in strategic plans, but in moving towards delivery and having systems on the ground. In relation to IT systems for vulnerable people, and potentially victims. It has been the case in the past that child sexual exploitation data has been difficult to draw from national systems because there hasn't been a common way of marking it. And I think that's been an issue across the whole of the United Kingdom in terms of understanding the scale and nature of the problems that we seek to resolve. Notwithstanding that, and the fact that we have invested in trying to get everybody up to the same standard in Police Scotland while we move towards a national system, I would agree that there is value in recording information about perpetrators, and we do have national systems for doing that. We have the Scottish Intelligence Database, where any information about perpetrators, which is intelligence, would be recorded. And if it was progressed through investigation to the point of evidence, then it would remain recorded on the intelligence database, but it would also be held on national systems round about crime reporting and about reporting to the Crown Office and Procurator Fiscal Service. In relation to how we link in beyond Scotland, I think there are still challenges. This isn't something that necessarily just manifests itself in Scotland. Clearly there are models of grooming which are locally based, and we've seen some evidence of that. They're geographically based, they may use IT, but they are people who in effect reside in a geographical community and perhaps know each other for one reason or another, acting as perpetrators. Or indeed, it may be different people who are, as has already been said, targeting vulnerable young people because of their vulnerability, and sometimes they are in a collective in a particular place. So I think there's more work to be done in terms of joining that up across the UK.
Okay, thanks. Do you have a timescale? Clearly we've got the interim VPD at the moment. Do you have a timescale for full-scale VPD?
I don't have a timescale at the moment. As members may be aware, there are a number of proposals which are in development and which are yet to be approved for a national ICT system for Police Scotland. My understanding is that that is up for consideration again as soon as this week, and I'm not in a position to make any announcements about a national IT system having been approved, but my understanding is that it's in the very final stages of the proposal.
Okay, clearly that'll be welcome once it's in place. Thank you.
Thanks, Convener. It's a question to Mr Graham. Police Scotland, I'm taking you back to third sector involvement again. Police Scotland has called for increased involvement within the third sector. There's kind of two questions here and there may well be a third. But firstly, why do you think that's important?
Why do I think it's important that the police are involved with the third sector? A number of reasons. I think the first reason is that the third sector are often the people who hear that child sexual exploitation is potentially happening. I think earlier on when there was a question to the Lord Advocate about the reporting of grooming offences, it struck me that actually the grooming offences very rarely get reported to the police. For the very reason that's already been stated, that perpetrators of grooming offences specifically seek their targets, knowing that the likelihood of them being reported is very, very low, and therefore it's something that we have to proactively seek out. Now, there are ways in which the police can do that, but there are different ways in which other agencies can do that, and some of the third sector organisations who are working day in, day out with young people and children, in our experience, are more likely to get a feel for something that's not right and be in a position to draw that to our attention, to share that information with other agencies. And I would hope that the police would be an agency that would come to a very early stage. I think there's evidence of very strong relationships across the country in that regard, and we should be able to act on that.
What do you reckon, what do you think needs to happen for that to take place? I mean, what structures do you foresee?
Well, I think there's a number of things that could be done. I think my experience of local partnership working is sometimes that the third sector do not always get an equal seat at the table alongside statutory partners. I think that more could be done to facilitate a greater degree of consistency in terms of third sector provision, where there are some fantastic pockets of work, but they're generally small programmes or at times pilots. which we would like to see rolled out. And indeed, I'm sad to say that in some cases, some of these pilots and some of the programmes that we've been working with, specifically around about young runaways, haven't had their funding continued, and therefore they would leave a gap potentially in terms of the ability for some of the third sector agencies to identify victims and therefore share that information with some of the agencies who can take action.
Last but not least, sorry, Convener, we have already taken evidence from some of the third sector agencies, and what they were saying to us was that they felt left out in the cold from the multi-agency meetings.
Yeah, I think that probably echoes the point that I'd already made. That my experience of local partnership working can be at times that the third sector don't always get an equal seat at the table. Now, in some cases, that is because they don't have the same range of statutory duties. In other cases, that is because of a local history and dynamic that needs to develop. And certainly, and I know that some of the evidence coming forward from the third sector supports this, in relation to the police, the creation of Police Scotland is an opportunity for us to direct and coordinate across the whole of the country what the level of engagement and the nature of that engagement with the third sector should be, to make sure that not only do we say that they're key allies in safeguarding children, but actually demonstrate that in every local community across the country.
Thank you.
I'd like to bring in Malcolm Chisholm to ask some questions of the Lord Advocate and Alison Durrell.
We're in the middle of the Victims and Witnesses Bill, so as you know, there's the extension of standard special measures to victims of sexual offences and domestic abuse, trafficking, stalking. So that's one side of it, although concerns have been expressed that there is also a right of appeal against that, which in fact is also going to include appeal potentially against children getting those special measures. So I just wondered, on balance, how you think the changes will contribute to the prosecution of cases involving child sexual exploitation.
Well, it's very important, I think, having led evidence from child victims, we're victims of different ages. In fact, in the witness box, I've led evidence from victims through CCTV, through screens, remote sites, evidence by commission. I have to say, I mean, this came in, as you know, a number of years ago, and my initial feel was that you would lose something if, for example, a victim gave evidence by CCTV or remote site. I've now, through experience, changed my mind on that. I think that you don't lose anything. And I think it's very important that victims, when they give their evidence, feel comfortable and that the criminal justice process aids the evidence giving of witnesses in our courts. It's absolutely right that you have to ensure a fair trial, and it's right that the accuser's concerns about evidence giving by alternative means has a right to be heard. So it's ensuring that the balance of fairness is always there in the trial process. But my view is that I support the Victim and Witnesses Bill and what they're doing on means of giving evidence. It may be worthwhile to hear what Alison's experience, because there's a development where child victims are giving their evidence by prior recorded statement. That's evidence in chief. That's been introduced, and then the child witness is then cross-examined, and we've, I think, had that in a number of cases recently with some success. So it may be that you might want to hear from Alison and her experience on that.
I think that's a great strength of NSCU because of the specialism. With that specialism comes actually confidence. Confidence to use the discretionary measures which have been in place, as the Lord Advocate says, for a number of years. And we have learnt through experience that the best way of taking a child or vulnerable person's evidence is that they are properly prepared and supported, so that when that child goes into the CCTV room and is questioned by the Advocate Depute, he or she will have met that Advocate Depute, at least once, if not on a number of occasions. I think we are more skilled at adducing evidence in a whole variety of ways, and I do have personal experience, very positive experience, resulting in convictions, where using the existing statutory provisions, we lead the child's prior statement as their evidence in chief, so it's there, that is the evidence, and then the process moves on to cross-examination. Now, years ago, that would be something quite daunting. We would be very uncertain about that, but experience and convictions have shown that that is the appropriate way forward in the appropriate cases. We are, with that confidence and expertise in NSCU, I really have the sense, and I can happily assure the committee today, that we are pushing the boundaries, the limits of the provisions that we have in the best way possible for the cases and for the victims to ensure we get the best result possible. And that extends further from special measures. We are taking our case into the appeal court, arguing for extension, for example, of the doctrine of mutual corroboration for as long as that is applicable. So that we, and it is really from experience with victims of child sexual exploitation and indeed a whole raft of sexual offences that we bring that confidence, as I say, to use more imaginative, more positive, more constructive ways of taking evidence.
Thanks, that's very helpful. Now, training obviously has come up with reference to that bill in general terms, but if I could just ask more specifically about training oriented towards child sexual exploitation for the Crown Office and Procurator fiscal staff. I mean, I think you've got some references to training in your paper, but no, I think for training specifically in issues related to child sexual exploitation. So that would seem to be a big area for development.
I think it's a subset of child sexual abuse, as has already been pointed out, and will form part of the discussions, the training, particularly because we have the bespoke legislative requirements that the Chair has already referred to, which we must be familiar with, we must be prepared to use where the evidence supports that. So rather than it being ring-fenced as a separate issue on which training is delivered, it's very much part of the continuum, as ACC Graham described it. It's part of child sexual abuse that we in the Crown Office have to respond to and prosecute effectively.
Could I just come in and one point about training, and it's something that, in preparation for this morning's committee, I noted. There was a reference to training police, prosecutors, teachers, etc., and judges, and I support all of that. The one thing that it seemed to me was missing was the public. In this. Now, it's twofold in training the public. Firstly, you've got to educate them to look out for the signs, but also our fact finders in serious cases are members of the public, the jury. And we've thought long and hard about how do you go about doing this. And what we are doing now is introducing expert evidence into these types of criminal trials. To educate the jury. For example, and I give the example of rape cases, it is a common phenomenon that victims of rape do not report rapes immediately to law enforcement. And it's a common phenomenon in many cases that there is no physical resistance of rape victims during the commission of the crime. Now, some members of the public might be surprised at that, and it's always raised as a point in favour of accused persons during a trial. But we know from speaking to experts in the field that there is counterintuitive behaviour. So part of that is to educate the jury that that is not significant. And we're doing that through expert evidence. So jurors are hearing this and hearing explanations for behaviours. And it's the same with children who are victims of sexual abuse. You have to look at the circumstances. You've got to, in preparing for trial, you've got to anticipate the lines of defence and do what you can to deal with them and educate the fact finders. And that is all part of the training, because it's not just the technical training of what section, what you need to prove, the essential facts. It's also training in evidence, presenting evidence, and explaining evidence to jurors.
No, I mean, I think that's really interesting, actually, and well, we could probably ask a lot more about that, but it has concerned me for a while just how, I mean, I think I wrote to you recently about the selection of juries, but that's one issue, but once you have selected a jury, how are they, you know, because they won't be familiar with those issues, and I mean, there's a constituent who was an expert in these areas on a jury just said she was appalled that the other members of the jury didn't have any of that background awareness that she had, but I don't know what you can do about that very easily.
Look, it's a very good point. In Scotland, and indeed down south as well, there is no jury research because the Contempt of Court Act 1981 applies. You cannot ask a juror post-trial, you know, what they thought of that, what they considered significant, what they didn't consider significant. So there's very little empirical research in relation to juries in Scotland. I'm aware that Lord Bonamy was allowed to do some research about 8 or 9 years ago into the jury in a drug importation trial, and the results were very interesting. And he found it an interesting process as well. There is a lot of research in Australia as to how jurors go about things. And if we actually look at the research in relation to rape cases in Australia, the points that I made about delayed reporting, there was quite a significant proportion of jurors in the research that thought that was very significant and very much a point in favour of the victim is incredible and should not be believed. You need to be careful about it because as members of the public you're bringing along to court to decide cases. And you want to make it as comfortable an experience for them without the fear of ridicule, of further, research, with a view to ridiculing that particular jury. The principle of finality applies in Scotland as it does across most jurisdictions in the world, so you've always got to be aware of that. But it's something I'm very interested in. Certainly, if you fancy a coffee, I could speak for about an hour on and longer on juries.
One final question, moving on to something different, pretty general question, really. What powers, actions and resources, in your view, are necessary to identify and combat those networks of perpetrators who do not just operate locally, but do so over wide geographical areas of Scotland and possibly further afield?
I mean, I think that's probably one for you, Malcolm. You want to comment, and then I can come in and talk about the prosecutorial resources.
Thank you. It leads on from the last point, I think, that quite rightly we found upon juries as being a flawed system, but better than all the rest, for the very reason that they represent the communities that we're all here to serve. Now, the wider point I would make about training in its widest sense in terms of awareness is that actually this is an issue that we need to raise awareness of across all the communities that, in my case, I serve and that people work and live in, and indeed that juries are drawn from. Now, that awareness raising in some respects has developed so far through media reporting, which isn't always directed at the audiences that might best need it, and isn't necessarily getting across the key messages that we think would be important in terms of educating people and raising awareness to what these issues are. If I go back some 20 years to when I first joined the police, then the journey that we have been on has actually been astronomically both quick and successful in its impact round about dealing with domestic abuse, recognising domestic abuse as something that does happen, that communities and that society needs to face up to, and that the police and other agencies need to deal with robustly to make domestic abuse unacceptable in today's society. Round about sexual crime, we came from a position where it was unbelievable to people that somebody in a child's family would abuse them. That was often, if it was spoken about, then it certainly wouldn't be reported to agencies. If it was reported to agencies, the information wouldn't be shared and action might not have been taken. And in relation to child sexual exploitation, again, we've perhaps come from a position where there was a sense of disbelief that some of these unspeakable crimes, where what bound the individuals who were committing them was their lack of empathy for the victims and the families that they impacted upon, and their deviance and ability to avoid detection and identification. So I do think that when we recognise all of that, and we recognise that we have senior leaders, that we have men in senior places standing up and speaking about issues which predominantly affect women in society, as rape and child sexual exploitation does predominantly affect women, then I think we should recognise the substantial progress that's been made. In response directly to your question, I think that there is a need for a more coordinated communications campaign, which draws out the evidence that we have of the nature of this problem, recognises the journey which I've just described in terms of the dynamics in society, which in the past have sometimes been resistant towards understanding the evidence and using that as a means of changing societal views and what's acceptable, which generally precipitates reporting to the police, and then making sure that we're also understanding that the world is changing. So there are different means by which people offend, the ability for people to use the internet and online means, and that can all be part of the coordinated marketing and communications campaign that I would recommend.
I'm going to try and close the session at 11 o'clock. Jim Eadie?
Sorry, thank you, Convener. I wonder, is John Wilson going to cover off the issue of risk of sexual harm orders?
No, on you go. Ask.
Can I ask Assistant Chief Constable Graham, you said in your opening remarks that the priority was obviously to keep people safe, and that the legislation is there to ensure that. Do you have any, can you tell us first of all the role of the risk of sexual harm orders? What role does that play, particularly in being able to protect people at risk from harm in the case of where the perpetrator has not been charged or convicted? And there appears to be some evidence that they are not being widely used as yet, but given that you said earlier that the new police structure was an opportunity to improve operational effectiveness, how do you see that developing over time?
Okay, thank you. I think risk of sexual harm orders are part of a suite of statutory instruments for managing perpetrators, and I would like to emphasise that whilst prevention through identifying vulnerable victims is key to addressing child sexual exploitation, we need to make sure that we are addressing and identifying perpetrators and intervening in a way that is safeguarding children. And that intervention may necessarily come at a point where we don't have sufficient evidence to make a report to the Crown Office, Procurator, Fiscal Service. And getting that balance is always very, very difficult, because if we don't have sufficient evidence to report somebody for a crime, then invariably we don't have sufficient evidence to take something forward for one of the other statutory means. The risk of sexual harm orders were intended as a means of filling that gap to some extent, and I think it has been the case under the 8 legacy police forces in Scotland that they haven't perhaps developed and been used as much as they could have been. There are 17 risk of sexual harm orders in place at the moment.
Can I ask why? I mean, according to our information, in Lothian Borders, Strathclyde and Central Police Forces, they've only each ever made only 2 orders.
I think it goes back to an earlier point about the 2005 Act, that in cases where you were able to gather sufficient evidence for a risk of sexual harm order, our experience is that you would have sufficient evidence to make a report to the Crown Office, Procurator, Fiscal Service for a prosecution, and therefore it wouldn't be appropriate to go for the lesser measure. So it's quite a discrete and unusual set of circumstances that fits the criteria. That doesn't mean that it's not a useful tool. Indeed, there are a large number of pieces of legislation that we would use infrequently, but when they are used, they're absolutely essential. And they have to be seen in the broader scheme of statutory instruments. At the moment, we have 4,251 registered sex offenders who have been convicted. 3,299 of those are currently in the community, and we have 213 SOPOs, which by my calculations about 6.5% of that population. The requirements on the, a sexual offences prevention order, which is a statutory instrument on the back of somebody being convicted or somebody who is a registered sex offender, which allows the police through the court to set conditions which will require an offender to do or not do certain things. So we have 213 of those in Scotland, which, as I say, is 6.5% of the population currently not in custody. Now, the legislation is onerous in terms of the police round about monitoring such orders to ensure compliance, and indeed, if there isn't compliance, then offenders are arrested and brought back before a court, and that's considered as a very grave matter. So I think the risk of sexual harm orders need to be seen firstly in the light of the circumstances in which we would gather evidence will often lead us to getting sufficient to report, and also in the suite of other statutory measures by which we manage risk.
Just briefly, to building on what Malcolm's just said, it's very important that when you're dealing with this, you just don't look at it in silos. And one of the two things, firstly, proceeds of crime legislation should be used where appropriate to try and disrupt and deter so that any profit is not reinvested. And secondly, one of the developments that NSCU has done is in relation to the Traffic Commissioner. A protocol was entered into by the Crown Office Procurator Fiscal Service and the Traffic Commissioner's Office, where you have, thinking of circumstances we did have, where someone was convicted of child sexual abuse, and it turned out that that person was driving a PSV with school children to school. And what we have there is an information sharing protocol on conviction with the Traffic Commissioner, who has powers to withdraw licences. And I think that's been used in at least one case that I know of. So, just to make the point, it's very important that, you use everything at your disposal.
Okay. Okay. Jackson?
Yeah, we've received some expressions of concern from child protection agencies who've made submissions to us about the leniency of sentencing for possessing and sharing abusive images of children. Certainly, I think they feel they are far from exemplary. One particular case, with which I'm sure you'll be familiar, which was drawn to us recently, was of a man who shared hundreds of images and films, and the sheriff was only able to impose a maximum 1-year custodial sentence because it had been decided he should be prosecuted under summary procedure. So could you explain to me the process involved in deciding how you go about prosecuting someone, whether it is under summary or solemn procedure, and what your view of the kind of impression given in terms of sentencing is?
Yeah, I mean, there's very detailed prosecutorial guidelines or instructions, as are referred to Procurators Fiscal and Crown Counsel when they mark these cases for whether or not it's on indictment or summary. And Procurators Fiscal have to follow, and Crown Counsel have to follow these instructions. They're kept up to date, they're kept under consideration, and we don't get absolutely everything right. Sometimes you get the odd marking decision wrong for them, and that's something which we always take into account, any comments made by the bench as to forum. And if there is criticism that we've got it wrong, we'll look at it and try and learn the lessons to ensure it doesn't happen again. One thing I've learned as Lord Advocate is I never comment on sentences imposed by the courts. I always take the view that's a matter entirely for the court. If we take the view that the court's got it wrong, then we have the option of an appeal on the basis that the sentence is unduly lenient. We'll exercise that, and we do exercise it from time to time. There's also the option of sentencing guidelines issued by the courts, and I think the courts have fairly recently issued sentencing guidelines in relation to child pornography. It's a horrific crime. It's not, as some people say, a victimless crime. There are victims. It may be that they're not Scots. They don't live in this country, but they may be Thai victims or whoever. So we always take a very serious view of that, of child pornography. And the majority of cases I mean, I can look out the figures after my appearance this morning, but my understanding is that, you know, a significant proportion of these types of cases are prosecuted on indictment.
So can I just briefly then ask ACC Malcolm Graham, I mean, you talked about the move in terms of attitude over recent years. Do you feel that sentencing reflects the change in public attitude and the kind of efforts that are gone into to try and prosecute individuals who are identified?
Again, I think sentencing is a matter for the courts. What I can say about indecent photos of children is that there has been a steady increase in the number of cases that the police have identified. If I go back to the comments that I made about grooming legislation, these are not cases which may be a widely held perception that are reported to the police. These are very rarely cases that would be identified by a third party coming forward and being a witness. These are cases almost exclusively which are identified through proactive and targeted efforts by policing, working with other law enforcement agencies. In 2010-11, we identified 225 cases. In 11-12, we identified 375 cases. And last year, we identified 595 cases in Scotland. That work will become part of the National Child Abuse Investigation Unit, which I mentioned earlier. It'll be coordinated across the country. And we take the proactive nature of our duty to target offenders who are taking, distributing, possessing, making indecent images of children very, very seriously. One of the reasons for that, notwithstanding in an agreement with the Lord Advocate's comments about every image representing a victim of a serious crime, one reason is also that there is a large body of academic evidence which doesn't agree on the percentage of offenders who will go on or have an intent to commit contact abuse, but they all agree that it is a high percentage of people who are involved in making or sharing indecent images, and therefore not only is it the children in the images that are being victimised, but our experience is that often there are other children who are at risk and need to be safeguarded through that proactive work.
Thank you. If I may, as I'm going to close in a couple of minutes, if I may just ask one last question. Several organisations have said to us that criminal proceedings should not solely rely on young people giving an account of their abuse, and that in the past they felt unable to speak to the police. There was a sense that nothing could then be done. They said that the staff were left trying to work with the young people while the risk still continued. Are police and prosecutors, and this is for all of you, are police and prosecutors seeking to utilise other forms of evidence in cases where a CSE has been identified?
Absolutely, Chair, and I think that's an important message to take away from today. It's about building strong cases. It's about not leaving the victim out to dry. We want to support the credibility of the allegation, as the Lord Advocate said at the outset of this meeting. So in NSCU, yes, we do take forensic and objective medical opportunities if they arise. The window for that is limited. If not, we are looking increasingly at social networking sites, mobile phone evidence surrounding adminicals to support on an objective basis what we are hearing or understanding from the victim, so that at the end of the day, the jury, and we come back to the jury, is supported and given confidence as to the credibility of the allegation. But strong cases, other sources of evidence is absolutely at the heart of what we're doing at NSCU in conjunction with the police.
Yeah, I would endorse that. I also believe strongly there's a need for better education in this at schools. Alison attended a conference, I think, in America, where the FBI demonstrated, where they put up, I think it was a 12-year-old girl on social media looking for friends. And it lit up, the board lit up like a Christmas tree, and they were able to say, he's a convicted, and these were people pretending to be, friends, 12-year-olds. And it's very important that message gets out to schools. If I could raise just one other thing, which I'd be grateful if this committee consider. just now the law in relation to grooming is that if you groom in Scotland and abuse in France, you can prosecute the abuse in France and the grooming in Scotland. But if you groom in Scotland and abuse in England and Wales, you can only prosecute the grooming in Scotland. You can't prosecute the abuse in England and Wales. Now that seems to me to be an issue which we have had difficulties in the past. There's extraterritoriality, which I proposed it in relation to terrorist offences in the United Kingdom. So going back to our experience, the Glasgow airport bombing, where that was tried in Manchester Crown Court, the Scottish allegations. Now, what I think is that law enforcement in the United Kingdom as a whole should work together to be able to do the best for the case and prosecute these allegations at the most in the most appropriate place. I just flag that up as an issue. I know it's not a direct response to your question, but I thought that take the opportunity to mention it.
ACC Graham, briefly, if you would.
Yep, thank you. In relation to founding upon the testimony or evidence of a witness, that is often the starting point where a report has been made. But as I've already described, it is our duty to ensure that we are proactively targeting perpetrators where no report has been made of criminality, and indeed the very nature of the subject that we're speaking about means that such a report is unlikely to be made. There's never been a time where we are using more and numerous different tactics in terms of identification, applying the covert methodology that we may apply to organised crime groups in a proportionate way, and where we are bringing to bear the skills, expertise and competence of people who would work on homicide inquiries and rape inquiries to deal with the specific dynamics of child sexual exploitation, and recognising that it is an area where expertise is required.
Right, I'll now finish the session by thanking the Lord Advocate, Ms DeRollo and ACC Graham for attending and being very clear in answering the questions. There may still be some questions that we will write to you about, but I'll now allow for a few moments for the witnesses to leave and for the witnesses for the next session to come to the table. Okay. We now consider agenda item number 4, petition 1460 on the improvement of services and resources to tackle chronic pain. As previously agreed, we take evidence from the Minister for Public Health and also from Healthcare Improvement Scotland. So I welcome the Minister and all the associated witnesses from Healthcare Improvement Scotland, Director of Scrutiny, the Director of Scrutiny and Assurance, Programme Lead, and Dr. Steve Gilbert, National Clinical Lead for Chronic Pain. I also welcome Jackie Bailey, MSP, to the session. I propose not to take any statements, but just to go immediately, if I may, into questions on the basis that anyone may answer any particular question. May I firstly start by addressing HIS Scotland? This whole issue hasn't been handled very well, and I just wonder if the Minister or HIS can give an early indication of how you'll start to capture data, relevant data, and ensure there's a clean reporting mechanism in place going forward.
Thank you very much, Convener. And to pick your point up, that there's certainly learning for us in Healthcare Improvement Scotland in respect of transparency, and that's a point that was acknowledged very much in Mr Glennie, the Chief Exec's letter to the committee. And indeed, it was very much a point that was accepted in the meeting on the 30th of April with the Cabinet Secretary. Data is a fundamental part of the actual understanding of the patient's journey, and in respect of how they access care, how they are managed within primary care, and how they subsequently moved into other more specialist services. And as we take this forward over the next 6 to 12 months, the capturing of data in a robust, transparent and understandable way will be a key issue for us. And I think that goes beyond waiting times into the understanding of the whole patient experience. Dr. Holsworth may want to pick up that point.
Yes, thank you. I've recently taken over as programme lead for this programme of work, and we've been working very closely on exactly that issue, working with our steering group, with our partners, etc. And we'll have by the end of this year some really robust data that will give a better reflection of patient experience, which is obviously very important, but also from an outcome perspective. So we're working with a number of partners on that, and we'll have a report available.
So we have an assurance that there were no more comments about the issue of data being sparse and of poor quality, that it may have been construed as misleading, that the documentation was not public-facing, and that we will have openness, transparency and robustness.
I can assure you of that.
Thank you. John Wilson.
Thank you, Convener. Could I open up by declaring a particular interest in this issue? As some of the panel will be aware, I'm one of the co-conveners of the cross-party group in chronic pain, along with Jackie Bailey and my colleague Jackson Carlo. Convener, it really is about the amount of data that is collected, recorded, and how that data is presented. A number of the submissions that we have received from individuals who are very interested in the delivery of chronic pain services are concerned that the data that is being collected or pulled together is not sufficient to actually record what's happening out there in the various health boards. And we know, and through the work in the cross-party group, we know that there has been a number of issues raised by individuals who talk about things happening in one health board area but not happening in other health board areas, and there seems to be a discrepancy of what's happening and how people are being dealt with, either at a primary level or by consultants. Would the Minister or anyone else in the panel like to comment?
Well, I don't think there's been any doubt about that there has been a patchiness in the way in which services have been delivered across different health boards, and different health boards have been moving at a different rate in this particular issue. And I think it's worth saying that his have taken on board the points that have been made about the process that they went through in terms of collating the data that they had, and also the report that they then published, and the need to make sure that that is done on a much more transparent basis, and also the data which they're using is much more robust, as Robin's colleagues have acknowledged and recognised, and they will seek to make sure they address that more effectively in going forward, and I'm confident they will. But yes, the data does provide an important resource for us to be able to evaluate the progress that boards are making in this particular issue. So in order to try and get a more consistent approach, that doesn't mean uniformly the exact same thing happening in every board area, because obviously there'll be different responses given the nature of a board's situation. That's why we have asked all of our boards to have in place a service improvement group who are going to be responsible for bringing forward the service improvement plan, which will be submitted to the Scottish Government by the end of this month. Then for that work then to be taken forward and to be built into their local delivery plans, so that for each of our territorial boards in 2014, there'll be a clear part of that will set out the progress that they plan to take forward in the coming year on improving services around chronic pain. We'll be taking forward some of that work that allows us to look at what planning and services are being proposed within local board areas, and also for us to then look at how we can make sure that's then built into their local delivery plans. So the local delivery plans are very clear. This is what the board say, this is what we intend to do, and how we intend to go about it, and we can see that very clearly in terms of chronic pain services. So hopefully that approach, along with the addressing the data aspects and how that data is captured, but also the service improvement groups and through the use of the local delivery plans, will allow us to make sure that we are able to measure it more effectively, and also to get a greater degree of consistency on how boards are taking forward this whole issue.
Mr Pearson, would you like to comment?
Just to echo that point, that the service improvement groups are fundamental in embedding the improvements on the ground, and there's been over the past 6 months very much a positive uptake in that from the NHS boards. And data will become important and increasingly important in capturing that patient's journey, so we understand the progress that has been made against where the original report was written in 5 or 6 years ago.
One of the issues that's came out from some of the individuals that's involved is the issue about the financial reporting of the budgets that are available by health boards to deal with this service. Are there any issues there that we should be aware of as a committee, and how boards are reporting and identifying whether or not there are budgetary constraints in delivering chronic pain services throughout Scotland?
Well, the budgetary aspect is that chronic pain services would be viewed as being a core part of an NHS board's service delivery, and it should be funded within their overall budget for whatever service they need to provide. What we have done is we have provided some pump prime funding to boards to allow them to help to establish some of the arrangements they need to put in place in order to improve services at a localised level. And some of that work will help to support the work the boards are taking forward around the service improvement groups. But the specific delivery of chronic pain services is something which would be funded through the overall budget, which boards actually have, in addition to the additional funding we are providing to boards in the way of pump prime funding to assist them in taking forward some of the work at an early stage.
Thanks, Convener. Social care model, Minister. In the Chamber debate on the 29th of May 2013, the Cabinet Secretary stated that the Scottish Government was very committed to the principle that services for sufferers of chronic pain should be delivered through not just a medical health model, but a social model. Can I then ask the Minister of Public Health exactly how the Scottish Government intends to achieve a social model of care for sufferers of chronic pain?
Well, a key part of seeking to deliver on the social model is to take a much more holistic approach as to the needs of someone who has chronic pain. So that's not necessarily just looking at the medical aspect, which is what the medical model would traditionally do, looking at what sort of treatment they require, what type of clinical intervention might be appropriate. But it means also, under the social model, looking at the impact that the condition can have on other aspects of their life, their daily activities, their lifestyle, their home environment, the impact it has on their employment, that much wider holistic approach to it. And part of the chronic pain service model which we're taking forward in Scotland is that type of tiered approach, the way in which services can be delivered at a localised level or supported through voluntary groups, looking at a range of different things to help to support an individual and to give them advice and information, to the more clinical interventions at a primary or secondary level as and when that's necessary. So I see the chronic pain service model as being a key part of providing that type of holistic approach to help to support someone. The other part to it is that in a number of our board areas now, we've moved towards having, some have established a chronic pain programme, others have got pain management multidisciplinary teams. And I think the days when a patient who is presenting with chronic pain should only see a doctor to try and get that addressed don't necessarily fit into delivering the social model. So that multidisciplinary approach is important. So you've got OTs and physios and others who can help to support someone in addressing some of the other consequences that can come about through chronic pain are addressed effectively. So the service model is important in terms of how we try to deal with things at different levels, and alongside that, the multidisciplinary approach from the different professionals who have all got a contribution to make in helping to deliver on what would be the intended outcome through something using the social model.
Thanks, Minister.
Okay, all right. Malcolm?
Obviously, an important part of this is the issue of patient participation. So I wonder what steps the Scottish Government is taking to ensure a greater level of patient participation in the continued development of services.
Okay. I mentioned the service improvement groups, and all 14 of our territorial boards will have service improvement groups in place. Within that, they will have a patient participation as part of that group. Alongside that, we have the National Chronic Pain Steering Group, and they're looking to increase their number of patient participation, or the level of patient participation in that programme, and they're presently looking at how they can have a greater number of patients on that. So both at a local level through the Service Improvement Group, and then the National Steering Group at a national level should have patient involvement in it.
How does that relate to his work? Perhaps Dr. Hull's work could say about how, in terms of the work that you're doing, or is that all part of the same thing, really?
His are leading on the national group, and part of that is where we are. One of the things with the creation of the service improvement groups is to look at how we can make sure that feeds in much more effectively to the national steering group. And at their meeting in May, I understand that was one of the discussions they had around how they can make sure that the leads for the service improvement groups at a local level can feed more effectively into the national steering group, and how they can also increase patient participation in that process. And that will help to make sure the link from a national to a local level is much more consistent. But I don't know whether Rob and his colleagues want to add more to that.
Thank you, Minister. Yes, just to reiterate the point, ensuring as an organisation, Health Improvement Scotland, we have a legal responsibility to ensure a duty of user focus. And one of the concerns we've heard through this process, and particularly through this petition, is about the public involvement in the Chronic Pain Steering Group. And Dr. Holsworth might want to just elaborate a little bit more about the thinking between the Chronic Pain Steering Group at the national level and the work underway at a local level through the service improvement groups.
Yes, I suppose just to reiterate, the Minister has said that what we are currently working on and putting in place through the development of these service improvement groups is to have strong public participation within those, and then to actually use the service improvement groups collectively to have a much stronger and a more robust link with the National Steering Group. We had a meeting in May of the National Steering Group, and the actual membership was discussed. There was an agenda item on that, and we recognise the need to have much more strong and reinforced patient participation on that. So we have got that work in hand, and we're taking that forward.
Angus?
Thanks, Convener. My point on patient consultation has been covered.
Thank you, Convener, and good morning, panel. We've already heard in evidence this morning about the importance of capturing data in a robust and transparent way. Mr. Pearson made that point in illustrating the need to do that so that we can understand better the patient's journey. The Minister said that it was important to evaluate the progress that NHS boards were making, and no doubt that will be of increasing importance as we seek to roll out the delivery of the local plans that you mentioned. But I'd like to understand from Health Improvement Scotland, in terms of the update report, there were a range of factors that were reported in the data spreadsheet, which were presumably part of the audit, but were not covered in the detailed findings section of the update report. Can you explain why that was the case?
Yes, and I said at the very start that on reflection it would have been preferable to have had all the data, not only on the website, but accessible within the report, and that's a point of learning for us as Healthcare Improvement Scotland. I think the balance that we struck was to try and produce a document that was accessible to the public, and the balance perhaps pitched the wrong way in the sense that that data was not readily available. That's a point of learning for us as an organisation, ensuring that our findings and our facts are available in future, and it's certainly a point we've taken away from this petition and the feedback that we've had. Dr. Holsworth might want to elaborate on that point.
Yes, just to reiterate that, as our Chief Executive said at the cross-party group, I don't think this was our finest hour in those terms, and I would agree with that. But we've taken those issues on board. Did you have any specific questions in relation to that, or was it just the
I've just posed one, but I would like to understand, is the reason why information on issues such as referral to spinal cord stimulation or the importance of waiting list initiatives, were they not included because you didn't have sufficient data, or you had sufficient data and chose not to include them?
Well, I think that with these, particularly with spinal cord stimulation and referral to residential pain management programs, there were very small numbers who were actually going on to that treatment. Some boards didn't have any patients going, some had one or two, and we felt that that wasn't really something we could draw a conclusion from. I think it was useful for us to have a look at how many people were going ahead for that, and to discuss with the boards, why are some boards sending a lot more, and why so we're looking at the variation there. But that's something from the tertiary part of the service model, where we're looking at very intensive pain management options like the residential or the spinal cord stimulation. I'm organising for the centres who perform these procedures to draw up their own referral treatment guidelines, and for their outcome measures to be more tied down, so that there's a collaboration between the centres that carry out these more interventional procedures.
But I think what you're saying to me is that there's, in some cases, a lack of information.
There was only a little bit of information.
Sorry,
and
excuse me.
Yeah,
what you're saying is that lack of information available rather than deliberate exclusion of information from the report. Is that what you're saying?
Yes, we felt that it wasn't something that we could report on, yes.
Okay. Can I have an additional question? And it's for the Minister on the development of an intensive pain management service. That's a commitment which the Government has made, and I think has been widely welcomed, drawing on the experience of patients who've had to access that service south of the border. Can you give us an update on where we are with that, please?
We're presently at the final stages of drafting the consultation, or NSS at the final stages of drafting the consultation. They've obviously also established a specialist group who are actually helping to inform us in that process, and we hope to publish a consultation next week.
Thank you.
Excellent.
I think I've already been outed by my colleague as one of the co-conveners of the cross-party group on chronic pain. Can I just want to, there are 2 or 3 things, I hope and I'll try and be very concise. Can I come back, because you have kind of entered into a bit of mea culpa and contrition over this report. But what I do want to understand when we're talking about, we see it's very important about patient participation, and who actually decides who the patient representatives are going to be? Because I would have expected them to be a bit more vocal. Now, I wouldn't want to necessarily characterise them as friends of the establishment, but I mean, who is responsible for ensuring that the patient representatives there are thoroughly independent and are asking the questions which might have led to this all being a bit more available publicly sooner? And how do we ensure going forward that we have the right patient representatives there and ones who will genuinely ensure that independent voice of the patients?
If I pick up the point in particular about how do we ensure that there is involvement, I think what we need to do going forward is to learn the lessons from this experience, but particularly in terms of ensuring that there's an active voice from the service improvement groups and how we ensure that that voice is played into the national steering group. And it's particularly important as we design services, whether it's local services or it's national services, that that voice is clearly heard. Dr. Holsworth might want to pick up the point about the actual involvement.
We are working very closely with some of the major patient representative bodies, so Pain Association Scotland, Pain Concern and the Alliance. And we are also then looking to build on the service improvement groups and to get more local representation. So we're trying to cast a very wide net to get those groups who are active advocates for patients, as well as actual pain sufferers themselves at local level.
We're full of anticipation then to see who these patient representatives are going forward. In consequence of the report, though, and not just because of it, but more generally, I think there was an underappreciation of where we had progressed to in relation to chronic pain delivery. And I listened, Minister, to what you had to say in regard to that. Now, you were with us fairly recently on the lack of application by health boards towards the strategy on insulin pumps and put in place a very robust, I thought, requirement on health boards to update you on a regular basis as to how they were making progress towards the plan, which in many respects they'd failed to do. How would you compare the reporting process you are requiring in relation to the provision of chronic pain services to that which you had put in place for the achievement of the insulin pump targets?
Well, I would say it's much more robust now than it has been in the past for chronic pain. So, for example, each of the service improvement groups for each of our boards have to submit their plan for us to consider. And we'll have that completed by the end of this month. And then we'll then be looking at how they then build that into their local development plan for 2014. And Scottish Government receives a draft copy of the local development plans for each of our boards so that we can then compare that against what was set out in their service improvement group and how they then intend to take that forward in their delivery in the coming year. So we have a robust mechanism in there that allows us to establish a clear pattern of how boards are taking it forward and also to see which boards are making more progress than others. And what we then have to do is make sure that at a national level is that the steering group are continuing to monitor how progress has been made at a localised level through the service improvement groups going forward as well. So a combination of these factors, the local development plan, the plans that have to be submitted by the service improvement groups and also the national steering group, I believe give us a robust architecture to monitor how we take this forward and to address any issues that might come up in due course.
Okay. And finally, just a third question. In the debate which we held in the Chamber, the Cabinet Secretary announced the consultation to which you've referred. And there are three principal options, I believe, that you're seeking to consult on. One is the original intention of the petition, which is a pain management centre equivalent to that at Bath. A second option was some sort of mobile resource. And a third was improved services within local environments. Obviously, the easiest to quantify in terms of the investment that would be required of these three options is the first, because there is an equivalent and one can understand what it would cost to set up a centre. Does the government have in mind, or is it out of all three of these options, the government's intention that a parallel level of investment would follow in either of these three options? And do you have in mind, or have you quantified what you think that level of investment in chronic pain management would be as a result of whatever option arises best from the consultation? Or could it be a mix of these, or is that wishful thinking really in terms of the level of resource that you would have available?
Sure. Well, you appear to be ahead of me because I haven't saw the consultation document yet, so I don't know if it's those three options. So, what do you call it?
I thought those were the ones the Cabinet Secretary
broadly,
announced.
that's broadly going to be in that sort of frame, I think it'd be fair to say. What we've said is that our intention is to, because I think during the course of the debate there were some members who thought that we were considering consulting on whether we should have a residential service in Scotland or not. That's not the case. We've given a commitment that there will be a residential service of some shape or form in Scotland. What we need to do now is to consult on the model of how that service is delivered in Scotland. And what we'll do is, when we launch a consultation next week, is during the consultation period, see what the views are. If the views come back around one particular option, and if that is, say for example, a single site option which has got an in-bed facility and it can also provide an outpatient facility, then we will consider what resource implications that will have for us. So, given the commitment to a residential type of service in Scotland, we will then have to look at what the outcome from the consultation is and then to consider what resource implications that has and how we then fund that particular service. So I don't want to get into a situation where we're saying, well, we've decided that we're going to go with X option or anything sort of idea because that's what the budget is. Let's see what the consultation says and then let's look at what the options are from that in terms of costs. What I should say is that what we have to be mindful of is that we need to try and provide a service in Scotland that can meet the needs of patients across the country. And I think during the course of the debate, the Cabinet Secretary made reference to the fact that we need to think about how, if we do have a single site option in Scotland, how do we make sure that we also provide necessary supports and advice in other parts of the country, in Grampian, in Highland, or in the Islands as well, where it might not be as accessible for those patients. So we have to, I think, find a service option that allows us to provide that specialist service that may be residential, but also to provide the support and assistance in the other remote areas where they may not be able to access that service as ready.
Thank you. Jackie Bailey.
Thank you very much. And as the third and final co-convener of the cross-party group on chronic pain, I think everybody's covered most of it, but nevertheless, the consultation on the specialist centre is indeed very welcome. I would simply make the observation that currently we think it's acceptable to send people from all parts of Scotland to Bath. So this is a vast improvement, whether it's a one-site centre or whether you explore other mechanisms of delivery. Can I also acknowledge as well the acceptance of the lack of clarity and transparency in the report? I think that allows us to move on and welcome the very helpful momentum injected by the Minister and the Cabinet Secretary. That said, can I pursue just a little bit what you're going to do with the data? Because if I picked you up right, we can expect that at the end of December, and I'm assuming that will be published. Will it include not just a measurement of patient and experience and outcomes, important though they are, but also the numbers in whole-time equivalents of clinicians, of nurses, of physiotherapists, of psychologists and occupational therapists? Because I think when you were describing a multidisciplinary team, you simply tick the box to say they had one, but there's clearly a difference between a fifth of a consultant and a whole consultant. So transparency on those figures would be particularly welcome. And equally, I think it might have been the Minister mentioned that there would be transparency on waiting times. I take it that's the first and the second appointment as well.
Yes, Convener, just on those points, the data is important, and it's important that we're able to demonstrate the mix of services on the ground, the range of staff that are involved, and we'll certainly pick up the point about waiting times as well, and the journey in respect of AHP and MSK musculoskeletal referrals as well. I don't know if Dr. Holsworth wants to.
I think you've covered it, that's great. That's very helpful. And one final question, Convener, that I don't think you answered to Jackson Carlaw about who currently decides on the patient reps on the National Steering Group. That's part one. Part two is I hear a lot of discussion about involving patients in the service groups, and I think that's admirable, but that doesn't replace direct representation on the National Steering Group. So are there plans to increase the number of patient representatives on the National Steering Group?
To answer the last question first, the answer is yes, and that's fundamental to us. As I said, in terms of our statutory responsibilities, it's duty of user focus. I don't think we necessarily in the past always got it right as to how we do it. We're learning from that, and we'll make sure there's broadening of the representation.
With respect, Convener, I don't think I got an answer to my first question, which was a repeat of Jackson's. So on the basis that I'm persistent, could I ask it again?
In the past, there's been, obviously, within Healthcare Improvement Scotland, decisions about who's been involved. I think we'll learn from that. I think we need to ensure that with the Scottish Government colleagues and ensure that there's a broadening of the representation on the group.
Sorry, Healthcare Improvement Scotland, as this huge organisation, decided? There's not one person in there that decided the makeup of the National Steering Group?
Convener, it's before my time in terms of in Healthcare Improvement Scotland, but happy to come back to the committee in terms of actually how that process was and engagement with individuals as to how the decisions were made.
I think that would be helpful. And I always like questions to say finally and then move on to the next 3 questions. Thank you. I think this has been very helpful. Things have moved on, happily. We now have the assurance of openness, transparency, robustness, so that the government, either the Secretary, Health Secretary, or indeed the Minister, don't turn up at meetings and are not aware of what the situation actually is. And I've no doubt that we will keep an eye on what happens there. Do we have a recommendation on this? So, as a result of the evidence session, it's a question for the committee as to we have several options, and you may have some to add. We can either close the petition under Rule 15.7 on the basis of the Chamber debate on chronic pain took place on the 29th of May, that the Cabinet Secretary, indeed the Minister today, is committed to establishing an intensive pain management service in Scotland, and that the Government has set out its aims for the implementation of the SSM over the 2-year period for which funding, as we heard, has been provided. That's one option. To defer further consideration, which might be the more sensible thing, to defer that consideration until November and seek an update from the Government on short-term commitments, such as the delivery of the intensive pain management service at that stage. Jackson.
Well, Convener, on the basis that I've ordered a cooked breakfast from time to time and then the waitress has forgotten to bring it, I think I'd be in favour of deferring until November until we actually see what the outcome of the consultation is and what we're actually going to receive before we move any further to the petition.
John Wilson.
Thank you, Convener. Maybe
it doesn't show, I have to say.
Maybe it's just Jackson in terms of delivery of breakfast, but that's another story. In terms of the consideration, I would agree with Jackson that we defer consideration until November, not only until after the consultation period and deliberation by the Cabinet Secretary and the Minister, but to hear once again in terms of Health Improvement Scotland and the reporting mechanisms and how they're going to improve on what was seen as a disaster the last time and trying to report what's happening out there. And can I suggest we defer till November, and hopefully by that time we'll have the consultation and decisions, as well as Health Improvement Scotland's improved reporting structures.
Is that the verdict of the committee? Okay. Can I then thank the Minister and the members of the Government, Mark O'Donnell, Rachel Dunk and Gillian Gunn, and members from Healthcare Improvement Scotland, Robbie Pearson, Leslie Holdsworth and Dr Steve Gilbert. Thank you very much for your time. I'm going to suspend now until to allow the witnesses to leave. feel I've read them back yet. Come on, Mr. Wilson. Go consider agenda item 5, which is the consideration of current petitions. Just bear with me while I get my paper here so we can go through them. Firstly, petition 1376, which was lodged in November 2010, a petition by Mr MacDonald calling on the government to take necessary action to bring about a ban on the free use of methanol with its relation to releasing aspartame. The recommendations we can, as you know, are reading from your papers, that EFSA, European Food Safety Authority, are re-evaluating their analysis, and that will not be ready until November. And there is a recommendation that we should continue the petition in order to await the results of Food Standards Agency research from EFSA. Is that agreed or agreed? Next petition PE 1441 by David Crichton on the flood insurance problems, which, as you will recall, was the subject of a debate, I think, in May. There are several recommendations. One is to write to the Minister for Environment and Climate Change to seek an update. As we know, there were negotiations going on between DEFRA and the UK insurance industry, which were supposed to have crystallised at the end of June. That has now been pushed back a month. The statement of principles are due to expire at the end of July. It's the suggestion we write to the Minister for Environment and Climate Change to ask what action he's taking to ensure that SEPA develops a new commercial licence as quickly as possible so that we can secure the appropriate insurance. There's also a suggestion that we write to SEPA to ask what steps are being taken to ensure that a new commercial licence is developed as soon as possible. John Wilson.
Convener, I agree with your suggestion that we write to the Minister and SEPA, but could I suggest we write to DEFRA as well, just to remind them of our particular interest in this matter and to seek assurances that this will reach an early conclusion and we can all, people who may be affected by the possibility of flood, are safeguarded in future insurance policies.
Very good. Angus?
I'm certainly very concerned that the issue has not yet been resolved through negotiations between DEFRA and the UK insurance industry. So I think it would be sensible to write to the Minister for Environment and Climate Change to seek an update on the negotiations as far as he's concerned. And I would also agree that a letter to SEPA should be undertaken by this committee to ensure that a new commercial licence is developed as soon as possible and to seek their views on that issue. So we'd certainly go with the first two recommendations.
Yes, Carlo.
Yes, in the evidence that we took and in the debate, the suggestion was very forcibly put that there would be no extension beyond the end of June. So I think we should welcome the fact that it has been extended to the end of July, but that principle having been established, I think it would be sensible in the letter that we write to say that having established the principle of extending by a month in anticipation of an agreement, we would very much welcome the Minister and the industry reassuring people that there will be pro tem extensions until they do arrive at an agreement. And since they've done it for a month, I now don't see that there's any great principle at stake in offering people that kind of reassurance.
I think that's a very good point. Anyone else? So we agree that we write to the Minister in the terms I expounded, and also to write to SEPA, and we also write to DEFRA. Okay. The next petition is PE 1443, submitted by Maureen Sharkey on behalf of the Scottish Care and Information on Miscarriage, asking the Parliament to urge the Government to offer all women who have suffered miscarriage investigations following one loss through miscarriage and to review NHS Scotland's policy. There is, and there was in your documents, a response, a comprehensive response from the Royal College of Practitioners. So the committee is asked to consider what action it wishes to take in respect of the petition now that we have that information, either to seek any further information, to refer the petition to the Health and Sport Committee, or indeed to close the petition on the basis that the Scottish Government states has stated its clear support for the current Royal College of Obstetricians and Gynaecologists guidelines. Do you have a view? Jackson Carlo.
I would move that we close the petition, convener, which the Scottish Government's expressed its view, which it says it's based on the evidence it has received, and from all the parties from whom we've sought to obtain that evidence, there has been a support for the present practice and position.
Malcolm? I mean, I think it's hard to argue with the clinical advice on that, but I was concerned just in terms of what the petitioner said in terms of the service is available. I think particularly the Royal College of General Practitioners said GPs should be prepared to offer counselling to women, and I think the petitioner was suggesting that this wasn't widely available. So, I mean, I wonder if it's worth taking up this point, because there obviously is an issue from the petitioner's point of view, and some of it may well relate to that side of things.
Anyone else?
Yeah, thanks, convener. Just to agree with Malcolm Chisholm, just to tighten up that sporadic nature of counselling, most parents don't know that that's available to them. I thought it was a great petition, and I'm not really sure where we go from here, convener.
The Royal College of General Practitioners stating that, that we would wish to see this incorporated meaningfully across GPs to those patients that are in this situation. But I have a sympathy with us having done that, then close the petition. Are you okay with that, Malcolm? Okay. So we're right to the petition 1446, lodged on October 2012 on the subject matter of congenital heart patients in terms of how we track those adults that suffer from that condition. We're asked to look at what action we wish to take based on the evidence and that we've had and subsequent correspondence. We can either close the petition on the basis that the Scottish Government has stated the first task of the Scottish Congenital Cardiac Network, the SCCN, is to look at standards appropriate for the Scottish service, that the funding for that has been increased by 60%, or to defer the consideration of the petition until the beginning of 2014 and seek an update from SCCN, or refer the petition to the Health and Sport Committee as part of its remit.
I've taken an interest in this, but I've asked some questions in Parliament about this. I mean, I would certainly support deferring it, but I also noticed there was a particular point raised by the petitioner, which I thought we should raise with the Minister, because this, the Scottish Government, you've got the paper from the petitioner, but basically the Scottish Government responded that the adult congenital population includes a large cohort of patients with minor lesions who do not need to be urgently followed up, and then she goes on to quote a recommendation from 2006 that all adults with congenital heart disease, whatever the level of complexity, are seen by an expert from a specialist centre, because I think one of the concerns is the number of people in the adult population who as it were, have got lost and are not identified by health services as having a problem. So I thought we should take that up with the Minister, but in general, I certainly would support deferring consideration. I think it's good that we've got the network, but clearly that tends to be the answer now. The network will deal with this issue and that issue, but I think we need to keep a watching brief on that. And my final point would be, given the issues that we raised with the last panel, to what extent there is patient involvement with that network.
Other comments?
The only other comment I would make is that it's not only about deferring it and to see what's happening and to write to the government, but I think it's also important that we allow the opportunity to examine the national standards that are then drawn up by SCCN and allow the petitioner to comment on those as well, because it would also be useful if the petitioner was somehow involved and the discussions
that marries what Malcolm was suggesting.
tying up with what Malcolm's suggesting in terms of how patients interact with this, the review, but I particularly draw SCCN's attention to the petitioner and the work the petitioner has done on this issue.
Okay, is that generally agreed? That we will write to the Minister and that we will also defer the consideration until the beginning of 2014. Next petition, 1448, lodged by Grant Thompson, calling on the Parliament to urge the Government to raise awareness of the links between organ transplantation and cancer. The recommendations are to write to the Government to ask what more can be done to make sure that all clinicians are aware of the potential risks in this area and knowledge is up to date, which seems immensely sensible, in order to ensure consistency across all NHS boards and the quality of information given to transplant recipients is consistent and doesn't vary. Alternatively, we could refer the petition to the Health and Sport Committee, or on the basis that we have now 3 Scottish transplant units and a Newcastle unit who have implemented the Scottish Transplant Group's recommendations, that we could close the petition. What is the committee's view? Angus?
I think the first option that you mentioned is the preferred option, to write to the Scottish Government to ask what more can be done to make sure that all clinicians are aware of the potential risks and that knowledge is up to date. So I would certainly move that.
Okay. Is that agreed? Anne?
Yeah, totally agreed, yeah. I think it's important that we continue the petition to ensure that the information is disseminated, and I think we've got to write and ask the Scottish Government about that first before we can consider closing the petition.
Okay. Do you agree? Right. Next one is P1458, which I would ask that we... Sorry, I beg your pardon, 1454. I've jumped ahead of myself. 1454, petition by Natalie Robert, calling on the Parliament to urge the Scottish Government to consider placing hyperemesis specialist nurses in hospitals. It sees consideration of serious vomiting in early stages of pregnancy. The recommendations are to refer the petition under Rule 1562 to the Health and Sport Committee, or to write to Dr McLean, from whom we have had a information letter supporting the proposal to form a network, hyperemesis network in Scotland, and that asks that interested parties such as the petitioner are included in taking this forward, or any other action you consider. I actually consider that setting up a network involving the petitioner and those who are affected or interested might be the way forward. Is that agreed? 1458 I'll take at the end, because I think we have more commentary on that. 1468, which is a petition lodged on behalf of Govan Law Centre, calling on the Parliament to amend Section 16 of the Housing Scotland Act. We have been asked to consider what action it... Right. Can I just stop? Sorry. May I remind members of the public in the gallery? Excuse me. Excuse me. May I remind members of the public in the gallery that it must be silent and not demonstrating, either by vocal means or other pictorial means, when proceedings are underway, and should behave in an orderly manner. If you fail to do that, I will suspend the sitting, you will be asked to leave, and then we will continue with our business. The dignity of this Parliament will be protected. 1468. On behalf of Govan Law Centre, the committee is invited to consider what action it wishes to take, either to refer the petition under Rule 1562 to the Welfare Reform Committee for further consideration as part of its remit, or to take any other action which the committee considers appropriate. Malcolm.
I certainly support this petition personally, but I think procedurally it would be good that it went to the Welfare Reform Committee, because I think they've obviously been addressing all of these issues, and it's clearly a key issue for them. So I think procedurally that would be the best action to take.
Jackson.
I would move that we close the petition on the basis that the Cabinet Secretary has made clear that the Government do not intend to act on the petition, and that is the view of COSLA and the various other organisations who have responded to it, particularly in terms of the legal point about hypothecating the particular issue in terms of law.
I support Malcolm Chisholm's proposal that we submit this to the Welfare Reform Committee, along with the evidence that we've gathered to date, because I think we have, as a committee, managed to get some further evidence and responses, and it is the Welfare Reform Committee that are dealing in the main with the range of welfare reforms that are currently being passed by the UK Government, which impact on very harshly on many residents in Scotland and elsewhere.
Jackie Bailey.
Thank you very much, Convener. Could I support the view expressed by both Malcolm Chisholm and John Wilson? Members of the committee will know my support for this particular petition, but also support to protect people from eviction arising from the bedroom tax. It is also the case that I don't believe any guidance has yet been issued by the Scottish Government that would help local government in dealing with this. So sending it to the Welfare Reform Committee, if you were minded to do so, I think would be very helpful. And it may well also be that the Welfare Reform Committee might be invited to invite the petitioner along, because I think there were certainly some questions that you wanted to ask of him, and unfortunately he wasn't present. So thank you.
If we do that, that will be a matter for the Welfare Reform Committee. Any other views?
Just that I entirely agree with what Jackie Bailey has said. I think it's important that we do refer it over to the Welfare Reform Committee.
Angus?
Convener, yes. I mean, clearly we all have constituents who are paying the price of this UK Government initiative. However, there are a number of salient points in the response from the Scottish Government which should be noted, and in particular that the rationale for the measure is not of Scotland's making. The measure runs roughshod over devolved policy making, taking no account of Scotland's housing and homelessness policies, and the Scottish allocation of the DWP discretionary housing payment fund is entirely insufficient. So I think it's worth making these points at this point prior to the petition moving forward to the Welfare Reform Committee.
You're in favour of that?
I am, yes.
Okay. Jamidi?
I would just indicate, Convener, that I would fully support and endorse those comments made by colleagues who wish to refer the petition to the Welfare Reform Committee. It's very important that we don't dismiss this issue, but it is properly considered.
So, committee, by majority, decides it goes forward to the Welfare Reform Committee. Okay. Petition 1469, submission by Eileen Jackson on neighbour notification for distances for wind turbine planning applications. To enable an increase in the current neighbour notification distance of 20 metres. This sometimes has created difficulty. I know from personal experience of cross-boundary, cross-council boundary. Cross-council boundary applications, the options including us looking for any further information, to refer the petition under Rule 1562 to Local Government and Regeneration Committee for consideration as part of its work programme on the NPF and the SPP, or to close the petition under Rule 15.7 on the basis that the Scottish Government has no plans for a further review of neighbour notification or other publicity requirements for planning applications and COSLA. Jackson.
Convener, I'd actually like not to advocate any of those, but to suggest that we defer consideration of the petition until the autumn, because I note in the response from the Scottish Government the paragraph which says, while some amendments to the general publicly requirements are about to be laid in Parliament as part of consolidated planning regulations, we have no plans at present for a further review of neighbour notification or other publicity requirements for planning applications. We will, however, consider further the issues raised by the petition and the committee's discussion and update the committee in the autumn. So we have a commitment from the government to come back to us with how they intend to take forward these issues, and I think I would like to defer and remind them of that commitment and defer until we receive a report from them as to what they intend to do.
I think that's very sensible. Do we agree? Thank you. If we go back to 1458, if I may, on the issue of the meeting with, or the petition regarding declaration of the register of interests for the members of the judiciary. The recommendations were are included in terms of what action the committee wishes to take, one of which is to invite Moy the JCR, to give evidence to the committee at a future meeting, or to take any other action that the committee considers appropriate. Before making any personal comment, I'd really like to have the views of the committee. Just to remind me, at the last meeting, the committee took a decision that there would be no further purpose in pursuing the Lord President. I made a personal point that I thought that to leave this, particularly in view of the fact that a government-appointed individual like the JCR has particularly strong views, that while we were talking about the constitutional principle, or the Lord President wants only to talk about the constitutional principle, that constitutional principle would need to be seen in the light of potential what might or might not happen in any constitutional changes going forward. So the view was that we should seek to close this off with him, but I would certainly recommend that we have Moy Aloy in here. Is it Moy Aloy or Moy Ali in here to hear her views?
Convener, I would agree with that. I, in some respects, thought that matters had progressed to something of an impasse, but when I saw the support for the proposal emerging from the Judicial Complaints Reviewer, who is established under the Judiciary and Courts Scotland Act 2008 in that position, I felt that it would be, given the weight of evidence so far from the establishment has been of one colour, it would be interesting to hear from somebody who exists in an official capacity why they take a different view.
Malcolm. So I've not been involved with this, obviously, so I'd really like to ask a question, because obviously I have read about Lord Gill and his view of judicial independence in relation to attending the committee and answering questions, but is his and other objections to the register, is that based on the same principle of judicial independence, or is it really not to do with that at all? Because I don't know if anybody can answer that question, because it seems to me the very interesting general questions about the line between judicial independence and accountability, political oversight are kind of raised by this particular petition. Partly, in fact, in relation to another issue that I raised in the debate on victims and witnesses last week, where there was another issue about judicial independence. So I was really curious about that in terms of...
I think the view that was taken was that there are other means and mechanisms for checks and balances in terms of recusal, for example, that secures, secures the independence of the judiciary, but it doesn't expose them to to what they could, what I think is seen as a breach of the Scotland Act, and a breach of how they can actually perform in the role.
The register itself would be rather than just appearing here to answer questions about it. Is that what you're saying?
Well, that's difficult. Why we're struggling to see what when we're looking for openness and transparency, that the Lord President has chosen not to attend to explain why there should not be a register of interests for, as there is for MPs, the police authority, and just that's been his view. Jackson.
Convener, I think Lord Gill's response, which was actually something of an impasse from our point of view, was it's not happening down south. I and nobody else has any intention of doing it. Get your tanks off my vested interest lawn. We were unable actually to find a way to break through that. I think that's why the information that we've received from the Judicial Complaints Reviewer potentially offers us an interesting additional extension of the discussion. But I don't think the actual interest of the petitioner was ever properly and fully addressed beyond saying, I don't happen to think it's necessary, and neither does anybody else who is currently employed in this profession, surprisingly.
John.
I agree with Jackson Carlo that given that we've had the response from Judicial Complaints Reviewer, and I think very interesting comments within that response, it would be serve the committee some purpose to actually invite Moy Ali to give evidence and submit themselves to questioning by the committee to discuss this further. Hopefully, once we've had that evidence session, Lord Gill may reconsider his position in relation to section 23, subsection 7 of the Scotland Act 1998, which basically, as my interpretation would be, we are not allowed as a parliament or as committees of the parliament to call forward judges or sheriffs who are in relation to either judicial decisions that they have made and be accountable for those judicial decisions. But given Lord Gill's role as the Lord President, which is overseeing the judiciary as the petitioner's main point, I think hopefully Lord Gill may reconsider his position in light that we are taking further evidence, and hopefully in that further evidence session we will draw out other issues of relevance to our deliberations. So I would support Jackson Carlo's assertion that we bring along the Judicial Complaints Reviewer to give evidence to the committee and take it forward from there.
Okay, I think we should do that. We'll invite Moy. I have to say, it's somewhat paradoxical that having attended the Justice Committee, we were talking about the court service, that he was happy to come along there and explain the rationale behind that, or not, as the case was. Okay, thank you. Is there anything else on any of the petitions that we've discussed?
Just to reinforce the points made by Mr. Carlo and Mr. Wilson, I think, notwithstanding the point that is made by the Lord President in his letter to the convener of the committee, that judges cannot be compelled under the Scotland Act to appear before committees of the Parliament. I do note the statement in that letter that a register of interest for the judiciary is both unnecessary and unworkable, and it would have been beneficial if the committee had been able to hear oral evidence from the Lord President as to why he thinks that is the case. And like John Wilson, I hope that that is something that he would reconsider, but I would certainly endorse the view that we should hear further evidence from other expert witnesses on this subject.
Okay, agreed. Sorry, Angus.
Convener, could I draw the committee's attention to the letter from the petitioner that we received recently, in which he asks the committee to approach the New Zealand Green Party member, Dr. Kennedy Graham, of the New Zealand Parliament, who's currently putting his bill through. The bill is a Register of Pecuniary Interests of Judges bill, and I believe it's still currently going through the New Zealand Parliament. It might be an idea to approach him to see if he has any further views that he could give us.
Well, you write to Mr. what's his name?
Kennedy.
Email. We need to be very specific about what questions we're asking. I mean, there's recusal again, which the tense of the suggestion is that that's the way that the New Zealand government is tending to move. But I mean, there's no harm as we can select questions to send to them in terms of, so we can send. You got other questions? Well, he's brought, yeah, we can write to him, but you've also got to, if you look at the correspondence, the New Zealand government are now considering it, but there's the government, I think, is taking a view that they'd rather go down the route of saying what the recusals have actually been practiced, but there would be no harm in why don't I formulate some questions, zap them around everybody, see if we could actually write?
Yeah, that'd be fine, yeah.
Potential future evidence session involving experts first of Scotland. I know that certainly when the Health and Sport Committee considered the issue of minimum unit pricing of alcohol, we benefited greatly from evidence from experts in Canada, notwithstanding the time differences between the two countries.
I thought you were suggesting you were going to go out there to speak there. Right, we've covered the position. Now, as agreed at agenda item 1, the committee will now go into private session for the final 2 agenda items.